Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Where the hell am I? Well, I'm on the banks of the Spokane River out here in beautiful Spokane Valley. We're doing some work in Spokane and North Idaho over the weekend, but as you may know, we got huge news out of the United States Supreme Court today. That's right. We have finally gotten the ruling in United States v. Rahimi. Now, for those of you who regularly geek out on the channel, you will know that we predicted that Rahimi was going to lose 7-2. As it turns out, Rahimi actually lost 8-1. But there's a lot to dissect here. We're only going to get through kind of a superficial view of the opinion. We'll do some more geeking out and some better videos, maybe when we're not on the bank of a river later this weekend. But today, let's start geeking out. Let's start getting you all educated, and let's talk about the United States Supreme Court weighs in on Rahimi. Okay, hey, before we get going too far down the road, we are going down. You know, we tell you here all the time at Washington Gun Law, we're not going to tell you how to think. We're just going to give you all the stuff to think about. Well, does the news treat you the same way? And that's why I've been using ground news, because in today's world of media bias and censorship, ground news gives you the freedom to learn for yourself, attach your own weight to the facts, and come to your own conclusion. Wow, what a concept, huh? Here's how it works. Take today's story, for example. You start searching it out, and now, 1, you can see who the news source is and what is their political leaning. 2, you can learn who actually owns those individual news sources. 3, you can see the headline manipulation, so now you understand how the story is being distorted. And most importantly, 4, the biased distribution of each story. But then there's a lot more cool features. Like Discover Plus, which is unlocked only with a Vantage plan. But here you can customize your own news feed to cover the topics that interest you the most, like, you know, Second Amendment news. Then Ground News will populate your news feed based upon these settings. Here's the best news. Right now, you can get 40% off a Vantage plan by visiting ground.news/Washington. Listen, it's time that you break free from all the media bias and manipulation. It's time that you start being able to make up your own mind. It's time for the news to start treating you like an adult. For more information, visit my good friends at ground.news/Washington. Okay, America, here's what we're talking about today. We are talking about the case that we have all been anticipating. It is the case of United States v. Rahimi. The opinion came out just about an hour and a half ago. We ran down here to the banks of the river to start getting this video shot after we had a chance to skim through all 108 pages of the opinion. Yeah, it is a long opinion. There is concurring opinions. There is one dissenting opinion. There is one justice who did not agree with that. That is Justice Thomas. The majority opinion is authored by the Chief Justice, John Roberts, and the court's opinion basically states the following. When an individual has been found by a court to pose a credible threat to the physical safety of another, that individual may be temporarily disarmed consistent with the Second Amendment. Since the founding of the nation's firearm laws have included regulations to stop individuals who threaten physical harm to others from misusing firearms, as applied to the facts here, Section 922G8 fits within this tradition. So where the Fifth Circuit has found that 18 United States Code Section 922G8 was unconstitutional, the United States Supreme Court has overruled that decision, has reversed it, thus re-implementing 18 U.S.C. Section 922G8. Now, the court went on to further state, the right to keep and bear arms is among the fundamental rights necessary to our system of ordered liberty. That right, however, is not unlimited. The reach of the Second Amendment is not limited only to those arms that were in existence at the founding. Rather, it extends prima facie to all instruments that constitute bearable arms, even those that were not yet in existence. Now, that is not unique case law, but the re-announcement of that likely means that some of the other cases sitting on the doorstep of the United States Supreme Court could easily be GVR'd, granted, vacated, and then remanded with instructions to rule consistent with the Rahimi decision. This all comes down to limiting who the United States government can disarm to those individuals who are deemed to actually be dangerous, as the court put it. Rahimi's facial challenge to Section 922G8 requires him to establish that no set of circumstances exist under which the act would be valid. Here, Section 922G8 is constitutional as applied to the facts of Rahimi's own case. Rahimi has been found by a court to pose a credible threat to the physical safety of others, and the government offers ample evidence that the Second Amendment permits such individuals to be disarmed. And that, I want you to understand, is going to be the big distinction here. A credible threat as harm to others. So when we're getting into cannabis users, when we're getting into people such as Mr. Range, who just committed food stamp fraud like 3 decades ago, do they pose a threat to others? No, they do not. Now, the court found that even though there was a need for historical traditions, those traditions were rooted in some of America's early surety laws. Together, the surety and going armed laws confirm what common sense suggests. When an individual poses a clear threat of physical violence to another, the threatening individual may be disarmed. Section 922G8 is not identical to those founding era regimes, but it does not need to be. And again, relying heavily on these surety laws, the court essentially hung its hat as that being the historical tradition here. Like the surety and going armed laws, Section 922G8 applies to individuals found by a court to threaten the physical safety of another. This prohibition is relevantly similar to those founding era regimes in both why and how it burdens the Second Amendment right. Section 922G8 restricts gun use to check demonstrated threats of physical violence, just as the surety and going armed laws do. And so ultimately, the court has found that this is a permissible restriction on an individual's Second Amendment rights based upon evidence that they pose a physical threat to others, as the court put it. The burden that Section 922G8 imposes on the right to bear arms also fits in within the nation's regulatory tradition. While the court does not suggest that the Second Amendment prohibits the enactment of laws banning the possession of guns by categories of persons thought by the legislature to present a special danger of misuse, Section 922G8 applies only once a court has found that the defendant represents a credible threat to the physical safety of another. Section 922G8C1, which notably matches the similar judicial determination. And again, that language right there is likely going to get United States v. Daniels, as well as Range v. Attorney General of the United States, GVR'd, because the court there, and we had hoped for this, is clearly carving out an exception, saying, listen, if they're dangerous, yeah, we can have a discussion about disarming them. If they're irresponsible, if they're unlawful, if they've committed some type of criminal conduct in the past, that does not fall into the category of individuals that we as a society have accepted in disarming. Ultimately, the court has come to this conclusion. The Fifth Circuit erred in reading Bruin to require a historical twin rather than a historical analog. The panel also misapplied the court's precedents when evaluating Rahimi's facial challenge. Rather than consider the circumstances in which Section 922G8 was most likely to be constitutional, the panel instead focused on hypothetical scenarios where the provisions might raise constitutional concerns. And then finally, and again, this is really important for the cannabis users out there, the people who have some nonviolent felony convictions, because I know you were waiting to hear this. And at the end of the day, Rahimi lost, but I always said Rahimi could lose and you could still win. And it's language like what I'm about to share with you here that explains why nonviolent felons may have significantly benefited from this ruling today. Finally, the court rejects the government's contention that Rahimi may be disarmed simply because he is not responsible. The court used this term in Heller and Bruin to describe the class of citizens who undoubtedly enjoy the Second Amendment right. Those decisions, however, did not define the term and said nothing about the status of citizens who were not responsible. Okay, and just to make sure you guys understand, and I got my little laptop here with me here, Chief Justice Robert delivered the opinion of the court in which Alito, Sotomayor, Kagan, Gorsuch, Kavanaugh, Barrett, and Jackson joined. Sotomayor filed a concurring opinion in which Kagan joined. Gorsuch, Kavanaugh, and Barrett and Jackson filed concurring opinions, and Justice Thomas filed a dissenting opinion. We're going to go ahead and link up the opinion down below so that you guys can start geeking out on it for yourself. We got 108 pages we still got to get through. We're going to get through it. We're going to get more videos out over the weekend here from either Spokane or Idaho so that you guys can get yourself further educated. Maybe you got ideas for videos we should be doing here at Washington Gun Law. If you do, click on that link right there. If you got questions about this, you should know how to get a hold of us. All of our contact information is right down there in the description box. And then finally, and most importantly, Let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. From the beautiful Spokane River, thanks for watching and stay safe.